Imagine this. Moving day. The truck is parked right outside your new place. Everything you own is locked inside. And the driver just handed you a new invoice for twice what you agreed to pay. You can call the police. They'll tell you it's a civil matter. You can call a lawyer. By the time anything happens, your stuff is already in a storage facility, racking up fees you also didn't agree to. Here's the part that should make you angry. In most states, what that company just did is completely legal. Before this video is over, you're going to know exactly what to sign, what to never sign, and what to say if this ever happens to you. This is Law Drop. Everything we cover here is for informational purposes only and does not constitute legal advice. Laws vary by state. Now let's get into it. Stay with me, because the legal loophole that makes this possible is hiding inside a single word on your contract. Tens of millions of Americans move every year, and most of them do the same thing. They go online, get a few quotes, pick the lowest one, and sign whatever the company sends over. That's the mistake. The Federal Motor Carrier Safety Administration, the agency that's supposed to regulate moving companies, received over 6,000 complaints in 2023 alone. Unauthorized charges, held belongings, inflated bills at the door. The average victim of a predatory moving scheme loses around $1,200, according to BBB complaint data, and that's only among the cases that get reported. That's not counting the belongings that never come back. That's not counting the days of missed work. That's just the extra money handed over at the door, above and beyond what was already quoted. And here's what makes this particularly cruel. Moving day is already one of the most stressful days in a person's life. You're exhausted. You haven't slept properly in days. Half your life is in boxes. You don't have a functioning kitchen or a place to sit down. And at that exact moment, when you're at your most vulnerable and least able to think clearly, that's when the driver hands you the new invoice. That timing is not an accident. And those are just the people who knew who to complain to. Here's what nobody tells you before you book. There are two completely different types of moving contracts. One protects you, one doesn't. And the company gets to decide which one you sign. Most people can't tell the difference until it's too late. When you hire a moving company, you're going to see one of two things on your contract: a binding estimate or a non-binding estimate. Those two words determine everything. A binding estimate is a locked price. The company assessed your belongings, gave you a number, and that number is what you pay. Doesn't matter if the truck is heavier than expected. Doesn't matter if the move takes longer. The price is the price. A non-binding estimate is different. It's just a guess, a starting point. The company can, and often will, charge you more at delivery based on actual weight, time, or services they claim were necessary. Here's the mechanic that makes it work. When you hire a moving company, they're supposed to estimate the weight of your belongings before the move. But in many documented cases, your stuff is never weighed in front of you. The company controls the scale. They control the paperwork. And on a non-binding estimate, that number, the actual weight, is whatever they say it is. There's no independent verification. There's no one watching. And the timing couldn't be more calculated. By the time the driver shows up with the inflated bill, your old place is empty. You've already returned the keys. Your new place may not even be ready yet. You have nowhere to go and no leverage whatsoever. Paying feels like the only option. That's not a coincidence. That's the design. Predatory companies deliberately lowball the non-binding estimate to win your business. They quote you $800. You book them. Moving day comes, and suddenly the actual weight is double what they estimated, and there are packing fees nobody mentioned. In one documented case reported to the FMCSA, a family in Nevada was quoted $1,200 for an in-state move. On delivery day, the company demanded $3,800 and refused to unload until they paid every dollar. The family paid, because legally, they had almost no choice. Now, the federal government does have a rule that's supposed to protect you from exactly this, but it only works for about half the moves that happen in America every year, and most people have no idea which half they're in. Here's the federal rule. If your move crosses state lines, if you're going from Texas to Florida, from New York to Ohio, from anywhere to anywhere in a different state, federal law limits what a moving company can charge you on a non-binding estimate. They have to deliver your belongings if you pay 110% of the original estimate. That's it. They can bill you for the rest later. But they cannot hold your stuff hostage for the full amount at the door. That's a real protection. And if a company violates it on an interstate move, you have grounds to file a complaint with the FMCSA and potentially pursue damages. But here's the problem. If your move stays within the same state, same city, same metro area, same state, federal law does not apply at all. The FMCSA has zero jurisdiction. And in most states, there is no equivalent protection at the state level. That Nevada family we mentioned, their move was intrastate. The 110% rule didn't apply. The company knew that, and they used it. This is how the math works against you. Most moves in America are local, same state, and that's exactly where the protections are weakest. But knowing the rule exists isn't enough. You need to know how to use it in the moment. If your move is interstate and the driver shows up demanding more than 110% of your non-binding estimate, you don't have to pay the full amount to get your belongings. Federal regulation says you have the right to take delivery by paying the original estimate plus 10%. Say it clearly. Use the words 110% rule and FMCSA regulation. Document the conversation on your phone. Get the driver's name and the truck number. The company then has 30 days to bill you for the difference, the amount above 110%, and you have the right to dispute that charge. That's the window. That's when you file with the FMCSA, contact your state attorney general, and depending on your state's small claims limit, consider taking them to small claims court. The 30-day window is federal law. Most people never know it exists, but it gets worse. Because there's a second trap most people fall into before they ever sign a contract, and it has nothing to do with the price. You've already seen how a single word on your contract can cost you thousands of dollars, and how the federal rule that's supposed to protect you doesn't protect you if you're moving across town. What's coming next is worse, because the company you think you're hiring may not even legally exist by the time you try to sue them. If you don't want to miss the rest of this video and what Law Drop is covering next, subscribe right now and hit the notification bell. Every video we put out is something your employer, your landlord, or your moving company is counting on you never finding out. Share this with someone you know who's planning a move. It might save them everything they own. Here's something the moving industry doesn't want you to know. A company can register with the FMCSA under one name, show up at your door under a completely different name, and by the time you figure out what happened, they've already dissolved the entity you're trying to sue. This isn't rare, it's a documented pattern. According to complaint records, some predatory operations run simultaneously under 5, 6, even more different business names. They rotate them. When one name starts accumulating complaints and bad reviews, they quietly shift operations to a new name with a clean record. In one documented investigation by the New York Attorney General, a single operation was found running under 6 different names at the same time. They collected deposits from customers under one name, showed up with a truck registered to another, and delivered, or didn't deliver, under a third. The investigation resulted in a $500,000 settlement and license revocation. But by then, hundreds of customers had already paid inflated bills or lost belongings to storage auctions. And here's what made it almost impossible to stop them. Every time one entity got shut down, a new one was already operating. Same trucks, same people, different name on the paperwork. This is why checking a company's FMCSA license number, not just their name, before you book is the single most important thing you can do. A license number follows the company, a name doesn't. And here's how most people end up with these companies in the first place. You go to a moving quote aggregator, one of those websites that promises to compare prices from multiple movers at once. You fill out your details, you get 3 or 4 quotes, you pick the lowest one. What you don't know is that many of these platforms accept payment from moving companies to be listed without verifying their license, their complaint history, or whether they're even the company that will actually show up at your door. Because that's the other piece. In many documented cases, the company you booked is not the company that shows up. A broker takes your booking and sells the job to a subcontractor, sometimes an unlicensed one, and that subcontractor is the one holding your belongings. The name on the truck doesn't match the name on your contract, and now you're trying to figure out who actually has your stuff. But even when you find the right company to go after, there's still a problem. Because while you're trying to figure out your legal options, your belongings are sitting in a warehouse, and the clock is running. So you refuse to pay the inflated bill. Good for you. You know your rights. You're going to fight this. Here's what happens next. The driver doesn't unload. He takes your belongings to a storage facility. Could be across town. Could be in another city. You might not even know exactly where. And from that moment forward, the meter starts running. According to complaint records, storage fees on held belongings can run anywhere from $50 to over $150 per day, depending on the company and the state. And in most states, there is no legal cap on what they can charge. Think about that. You refuse to pay $3,000. 2 weeks later, you owe the original $3,000 plus $1,000 more in storage fees. A month later, it's $2,000 more on top of that. Let's make the math concrete. You refuse to pay the inflated $3,000 bill on delivery day. The company takes your belongings to a warehouse and starts charging $100 a day in storage fees. After 1 week, you owe $3,700. After 2 weeks, $4,400. After 30 days, $6,000, double the original inflated bill. And you still haven't seen a judge. You haven't even had a hearing scheduled. The debt is just growing while the legal process hasn't started. And the timeline to auction varies, but it's shorter than most people expect. In states without specific notification requirements, some companies have moved to auction in as little as 30 to 60 days. In states with stronger consumer protection, the company must send formal written notice before auctioning, giving you a window to respond. But in the gray zone states we mentioned, the ones with no dedicated regulation, that window may not exist at all. By the time you find out where your belongings are, the auction may already be scheduled. And here's the part that most people don't see coming. Under what's called a carrier lien, a legal principle that exists in all 50 states, a moving company has the right to hold your belongings as security for an unpaid debt. If that debt isn't settled, they can move to auction your goods to recover what they claim they're owed. In documented cases, belongings have been auctioned before the owner even received proper legal notice. By the time some families found out, their furniture, their photos, their irreplaceable items, gone. Sold to cover storage fees that had been accumulating for weeks. And the legal mechanism that allowed it? Completely valid in most states. Now, where you live determines almost everything about what you can actually do if this happens to you, because the map of protections across this country is not what most people expect. Where you live, or where you're moving from, changes everything about how much protection you have. Let's go through the states. Start with the danger zones. Florida and Texas are consistently among the states with the most predatory moving complaints per capita. Neither has a dedicated state agency regulating intrastate movers. In Texas, anyone can start a moving company with no license, no insurance requirement beyond the federal minimum for interstate moves, and no state oversight for in-state moves. Florida is similar. High volume of moves, low regulation, and a well-documented history of hostage freight operations. Nevada, particularly Las Vegas, has a concentrated pattern of in-state predatory moving. Georgia has no mandatory state licensing for intrastate movers either. California is the strongest. The California Public Utilities Commission licenses and regulates intrastate movers. Companies must carry insurance, provide written contracts, and cannot charge more than 10% above a written estimate without your written approval. You can verify any California mover's license on their website in seconds. Most states have no equivalent rule. What that means in practice, if a California licensed mover tries to hold your belongings or charge beyond the written estimate without your approval, you have a direct path. You file a complaint with the CPUC. The agency has actual enforcement authority. It can investigate, fine, and revoke the company's operating license. That's not a guarantee you get your money back immediately, but it means the company faces real consequences. And companies that operate in California know that. Now, contrast that with Florida. If the same thing happens to you in Florida on an in-state move, you have no equivalent agency to call. The Florida Department of Agriculture and Consumer Services handles some consumer complaints, but there is no dedicated state licensing body for intrastate movers. Your options are civil court, a BBB complaint, or a complaint to the FMCSA, which, as we've established, only has jurisdiction if your move crossed state lines. If it didn't, you're largely on your own. New York and New Jersey have active consumer protection enforcement and a track record of prosecuting predatory operations. Illinois has the Illinois Commerce Commission with similar authority. No dedicated state agency, no licensing requirement for intrastate movers. If something goes wrong, your options are civil court or a BBB complaint the company will ignore. The state you're in right now may offer you almost no protection. Most people don't find that out until the truck is already parked outside. But even in states with protection, California, New York, Illinois, one document people sign without reading can wipe out every right we just described, with a single signature. Before any of your belongings go on that truck, the company will hand you a stack of documents to sign. Buried in the middle, a clause most people sign without reading. A mandatory arbitration clause. By signing it, you agree that any dispute will be settled through private arbitration. No judge, no jury, no public record. An arbitrator the company often has more influence over than you do. Class action lawsuits, where hundreds of overcharged customers join together, are one of the most powerful tools consumers have. In most cases, a mandatory arbitration clause eliminates that option entirely. You're on your own. One customer against a company that does this every day. Here's what most people don't realize. You can ask to have that clause removed before you sign. It's a negotiation. The company may say no, and that tells you something important about who you're dealing with. But a legitimate mover is not going to walk away from your business over one clause. If they refuse to move forward without the arbitration clause, that's a red flag worth taking seriously. And here's why it matters so much. Research on consumer arbitration outcomes consistently shows that consumers win significantly less often in private arbitration than in court, and when they do win, the awards tend to be lower. The arbitrator is often selected from a pool that the company has used before. There's no appeals process, and unlike court proceedings, arbitration outcomes are private, which means the company's pattern of behavior never becomes part of the public record, and the next customer has no way of knowing what happened to you. The federal government requires moving companies to give you a document before any interstate move. Your rights and responsibilities when you move. The FMCSA mandates it. It explains everything: binding versus non-binding estimates, the 110% rule, how to file a complaint. The problem? Most people never read it. And for intrastate moves, there's no federal requirement to provide it at all. Let's recap what's working against you. A non-binding estimate with no price ceiling. No federal protection for in-state moves. A company that may disappear overnight. Storage fees with no legal cap. A carrier lien that lets them auction your belongings. And a clause that takes away your right to fight back in court. But there are exactly 3 things you can do before you sign anything that change the entire equation. Three things. Before you hand over a single dollar or let a single box go on that truck. Number 1, demand a binding estimate, in writing, locked price before moving day. If the company resists or says it costs extra, walk away. A legitimate company will give you one. A predatory company will resist. Number 2, go to protectyourmove.gov. Look up the license number, not the name. Confirm the license is active, insurance is current, check complaint history. 5 minutes. Tells you more than any review site ever will. If they can't give you their FMCSA registration number, do not book them. Number 3, if your move crosses state lines, Federal law says you cannot be required to pay more than 110% of a non-binding estimate at delivery. Pay the 110% and contest the rest afterward. Say it out loud. Reference the FMCSA regulation. Document everything with your phone. The FMCSA has fewer than 200 inspectors for the whole country. The system depends on consumers who know their rights. The moving company is counting on you not knowing any of this. That's the only thing that makes the whole scheme work. Now you know. But if you're watching this and the truck is already gone, if this is already happening to you, there's still a path. First, document everything immediately. Every text, every email, every invoice, every conversation. Take photos of the truck, the license plate, the driver. Screenshot the company's website and reviews before they disappear. This documentation is your evidence in every forum that follows. Then move on 3 fronts simultaneously. File a complaint with the FMCSA at protectyourmove.gov. Even if your move was intrastate and they can't directly intervene, your complaint becomes part of the company's permanent record and can trigger an investigation. Contact your state attorney general's Consumer Protection Division. They have authority the FMCSA doesn't, especially for in-state moves. And depending on the amount in dispute and your state's limit, small claims court is often faster and cheaper than you think. In most states, no attorney is required, and moving companies frequently don't show up, which results in a default judgment in your favor. Before you close this video, think about one person. A friend, a coworker, a family member. Someone planning a move right now. They don't know what a binding estimate is. They've never heard of the 110% rule. They have no idea that the company they're about to hire might be operating under 3 different names. And they're about to sign whatever gets handed to them on moving day. That's who this video is for. Share it right now before you forget. The information costs nothing to pass along and could save them thousands of dollars and everything they own. If LawDrop has been useful to you, subscribe and hit the notification bell so you never miss what we cover next. Every video we put out is something the other side of the contract is counting on you never finding out. If this video opened your eyes, drop the word hostage in the comments. It helps more people find this video and tells us this is the content you want more of. This is LawDrop. Know the laws they hope you never find. We just showed you how a moving company buries an arbitration clause in your contract to take away your right to sue them in court. That same clause is hiding in almost every app, streaming service, and subscription you've ever signed up for. Every time you clicked "I agree," you may have already waived your right to ever take that company to court. That's the next LawDrop.